Hello, I'm Constitutional Attorney Catherine Henry, and this is a continuation of our series on the Florida State Constitution. This is part 6. We're going to dive right back in to Article 4 of the Florida State Constitution. And again, keep in mind we are not reading every single word of this Constitution because it is 6 times longer than the United States Constitution, including all of the amendments. So we're just going to be focusing on the most important aspects of the state constitution. And with that, here we go with Section 8, Clemency. Subsection A, except in cases of treason and in cases where impeachment results in conviction, the governor may, by executive order filed with the custodian of state records, suspend collection of fines and forfeitures, grant reprieves not exceeding 60 days, and with the approval of 2 members of the cabinet, grant full or conditional pardons, restore civil rights, commute punishment, and remit fines and forfeitures for offenses. Subsection B, in cases of treason, the governor may grant reprieves until adjournment of the regular session of the legislature convening next after the conviction, at which session the legislature may grant a pardon or further reprieve. Otherwise, the sentence shall be executed. Subsection C, there may be created by law a parole and probation commission with power to supervise persons on probation and to grant paroles or conditional releases to persons under sentences for crime. The qualifications, method of selection and terms, not to exceed 6 years, of members of the commission shall be prescribed by law. Section 9, Fish and Wildlife Conservation Commission. There shall be a Fish and Wildlife Conservation Commission, composed of 7 members appointed by the governor, subject to confirmation by the Senate, for staggered terms of 5 years. The commission shall exercise the regulatory and executive powers of the state with respect to wild animal life and freshwater aquatic life, and shall also exercise regulatory and executive powers of the state with respect to marine life, except that all license fees for taking wild animal life, freshwater aquatic life, and marine life, and penalties for violating regulations of the Commission shall be prescribed by general law. The Commission shall establish procedures to ensure adequate due process in the exercise of its regulatory and executive functions. The legislature may enact laws in aid of the Commission not inconsistent with this section, except that there shall be no special law or general law of local application pertaining to hunting or fishing. The Commission's exercise of executive powers in the area of planning, budgeting, personnel management, and purchasing shall all be as provided by law. Revenue derived from license fees for the taking of wild animal life and freshwater aquatic life shall be appropriated to the Commission by the legislature for the purposes of management, protection, and conservation of wild animal life and freshwater aquatic life. Revenue derived from license fees relating to marine life shall be appropriated by the legislature for the purposes of management, protection, and conservation of marine life as provided by law. The Commission shall not be a unit of any other state agency and shall have its own staff, which includes management, research, and enforcement. Unless provided by general law, the Commission shall have no authority to regulate matters relating to air and water pollution. Section 10, Attorney General. The Attorney General shall, as directed by general law, request the opinion of the Justices of the Supreme Court as to the validity of any initiative petition circulated pursuant to Section 3 of Article 11. The Justices shall, subject to their rules of procedure, permit interested persons to be heard on the questions presented, and shall render their written opinion no later than April 1st of the year in which the initiative is to be submitted to the voters pursuant to Section 5 of Article 11. Section 11, Department of Veterans Affairs. The legislature, by general law, shall provide for a Department of Veterans Affairs and prescribe its duties. The head of the department is the governor and the cabinet. Section 12, Department of Elderly Affairs. The legislature may create a Department of Elderly Affairs and prescribe its duties. The provisions governing the administration of the department shall comply with Section 6 of Article 4 of the state constitution. Section 13, Revenue Shortfalls. In the event of revenue shortfalls as defined by general law, the governor and cabinet may establish all necessary reductions in the state budget in order to comply with the provisions of Article 7, Section 1D. The governor and cabinet shall implement all necessary reductions for the executive budget. The Chief Justice of the Supreme Court shall implement all necessary reductions for the judicial budget, and the Speaker of the House of Representatives and the President of the Senate shall implement all all necessary reductions for the legislative budget. Budget reductions pursuant to this section shall be consistent with the provisions of Article 3, Section 19H. Article 5, Judiciary. Section 1, Courts. The judicial power shall be vested in a Supreme Court, district courts of appeal, circuit courts, and county courts. No other courts may be established by the state, any political subdivision, or any municipality. The legislature shall, by general law, divide the state into appellate court districts and judicial circuits following county lines. Commissions established by law or administrative officers or bodies may be granted quasi-judicial powers in matters connected with the functions of their office. The legislature may establish by general law a civil traffic hearing officer system for the purpose of hearing civil traffic infractions. The legislature may, by general law, authorize a military court-martial to be conducted by military judges of the Florida National Guard, with direct appeal of a decision to the District Court of Appeal, 1st District. Section 2, Administration, Practice, and Procedure. Subsection A. The Supreme Court shall adopt rules for the practice and procedure in all courts, including the time for seeking appellate review, the administrative supervision of all courts, the transfer to the court having jurisdiction of any proceeding when the jurisdiction of another court has been improvidently invoked, and a requirement that no cause shall be dismissed because an improper remedy has been sought. The Supreme Court shall adopt rules to allow the court and the district courts of appeal to submit questions relating to military law to the Federal Court of Appeals for the Armed Forces for an advisory opinion. Rules of court may be repealed by general law, enacted by 2/3 vote of the membership of each house of the legislature. Subsection B. The Chief Justice of the Supreme Court shall be chosen by a majority of the members of the court, shall be the chief administrative officer of the judicial system, and shall have the power to assign justices or judges, including consenting retired justices or judges, to temporary duty in any court for which the judge is qualified, and to delegate to a chief judge of a judicial circuit the power to assign judges for duty in that circuit. Subsection C. A chief judge for each district court of appeal shall be chosen by a majority of the judges thereof, or, if there is no majority, by the Chief Justice. The Chief Judge shall be responsible for the administrative supervision of the court. Subsection D. A Chief Judge in each circuit court shall be chosen from among the circuit judges, as provided by Supreme Court rule. The Chief Judge shall be responsible for the administrative supervision of the circuit courts and county courts in that circuit. Section 3. Supreme Court. Subsection A. Organization. The Supreme Court shall consist of 7 justices. Of the 7 justices, each appellate district shall have at least 1 justice elected or appointed from the district to the Supreme Court who was a resident of the district at the time of the original appointment or election. 5 justices shall constitute a quorum. The concurrence of 4 justices shall be necessary to a decision. When recusals for cause would prohibit the court from convening because of the requirements of this section, judges assigned to temporary duty may be substituted for justices. Subsection B. Jurisdiction. The Supreme Court, subsection 1, shall hear appeals from final judgments of trial courts imposing the death penalty and from decisions of district courts of appeal declaring invalid a state statute or the provision of the state constitution. Subsection 3. May review any decision of a district court of appeal that expressly declares valid a state statute, or that expressly construes a provision of the state or federal constitution, or that expressly affects a class of constitutional or state officers, or that expressly and directly conflicts with a decision of another district court of appeal or of the Supreme Court on the same question of law. Subsection 4. May review any decision of a district court of appeal that passes upon a question certified by it to be of great public importance, or that is certified by it to be in direct conflict with a decision of another district court of appeal. Subsection 6. May review a question of law certified by the Supreme Court of the United States or a United States Court of Appeals, which is determinative of the cause and for which there is no controlling precedent of the Supreme Court of Florida. Subsection 7. May issue writs of prohibition to courts and all writs necessary to the complete exercise of its jurisdiction. Subsection 8. May issue writs of mandamus and quo warranto to state officers and state agencies.